कैमरा ऑन करना। हेलो चेक ना आवाज इंग्लिश टाइप हो रहा है। हेलो हेलो चेक ठीक है।
But I think something.
Yes, item one.
Your Lordship, may I mention a matter? It's,
Mentioning, we thought you will stop mentioning.
Your Lordship, the matter is listed for tomorrow, the Supertech matter. Your Lordship was pleased to appoint a MICUS in this matter. On the last date of hearing, the MICUS had filed a 350-page report.
Mr. Rajiv Jain is the amicus.
Please, Your Lordship.
Yes.
Your Lordship, for your Lordship's convenience, I have summarized the entire report into few pages. May I circulate the same?
You circulate.
Grateful, Your Lordship.
My lords, one mentioning for tomorrow, there's a batch of review matters coming up before my lords. But because of some unforeseen circumstances, defective files have been circulated. My lords, we have cured the defects and refiled the same. If my lords may direct the same to be processed so that
2 days. Wherefore, once you remove the defect, 2 days.
Alright, it is already listed. The only exigency is, my lord, it is listed.
Please go and cure the defects. Matters will be listed. This is what we have decided.
Yes, my lord. My lordship is right.
And have patience and try this. Let us wait. If it doesn't happen, then please only make a complaint. Otherwise, wait for the.
My lord, tomorrow. Obliged.
pledge my lords.
Lord, I would like to mention one matter, my Lord, with your permission. It is diary number, my Lord, 67499. It is PIL, my Lord. It is regarding SIR process that is in continuing in Tamil Nadu, my Lord. The last date of SIR to be verification is 4th of.
Mentioning, please.
Lord, kindly list my matter tomorrow, my Lord.
Have you filed?
Yes, my Lord.
Have you cured the defect? Then wait for 2 days.
My
Yes.
lord, may I
Lord.
mention?
Next, now item one.
Item 1 is also a request for tagging, my lord.
Kerala matter.
Yes, my lord. This did not get listed, unfortunately. Will it also be tagged for tomorrow?
Tomorrow.
It's the same, my lord. It's a
Same.
obliged, my lord.
Wait, please, all. This comes up, this is regarding
Lordship, in
interpretation.
Item 2, if Lordship permit me, I have filed the another SLP challenging the same impugn order. But one petition is listed, my SLP is not.
Addendum sign and I let the elections take place, then we will hear.
We have no problem.
These are all delaying tactics. You just don't want the elections to take place. We will not entertain these.
Milord, I have no, Milord, I am not stalling the, requesting for stalling the elections.
Yes.
Milord, what has happened is this. Milord, this is in regard to the delimitation. Milord, we had raised an objection. Now there are two things which the High Court has completely missed. Milord, section 12. Milord, what I am requesting is this. Milord, what I am requesting, I am not even requesting for a movement. Milord, even for a moment, I am not requesting to stay the election. What I am saying is whether this delimitation powers are properly exercised. What happens is, if your lordship sees page 48, section 12,
Yes.
Milord, it empowers the state for
Delegation,
delimitation.
for only
But
problem.
approval is by the State Election Commission. Now here what happens is, the collector forms the delimitation and the commissioner approves it. And at page 72, if your lordship sees, the High Court says it has to be.
Order by which the election commissioner, CEC authorized divisional commissioner to exercise powers of approval.
I have
That is not challenged.
I have not challenged it. But
So if
the
that
fact
is not
remains-
challenged, then the issue
But
of
the
delimitation,
fact remains-
delegation was never
that was
raised at
what
the
happens
appropriate
is
stage.
this came up only at
Anyway,
the
now
time when
that
the
it has
hearing
been
was.
done, we are not
But
interfering.
your lordship may please see page
No.
72, what the High Court says. High Court says this has to be this needs to be looked into at deeper level.
Paragraph
But-
52.
Yes, paragraph 52, it says that it needs to be looked into at a deeper level, but doesn't look into it. Now, my lord,
Doesn't look into it for very obvious and just reasons.
my lord,
12th August order of delegation not under challenge. That is why the High Court says that.
your lordship may please see, is that not on that count, my lord. Please see page 72,
Thank you,
page
Mr.
50.
Chaudhary, thank you, we are not interfering.
Lord, please see, I'm
Yes,
not even
yes,
requesting
yes,
your lordship to,
petitioner to-
Lord, if your, what happens, there are two things which the High Court says, my lord.
We see no
May
ground
I-
to interfere with the impugned judgment of the High Court at this belated stage when the elections are like, when the elections to municipal bodies are likely to be held very soon. So however, the question of law in relation to the delegation of powers by the State Election Commission is kept open and shall be decided in appropriate
My
procedure.
lord, 12th June order has been challenged, my lord. That
Thank you,
your
thank you
lordship
very
sees
much,
page
thank you.
22.
Thank
That
you,
has
like the
been
election.
challenged. I don't wish to interfere, my lord. I am not seeking to stay the election. Your lordship may just issue notice and consider it.
Not interfere,
Very
you
well.
should not create any impediment of any type.
My lord, the complete injustice has
Thank
occurred.
you
my
very
lord.
much, thank you, thank you. Item,
Very well.
please.
This is Tamil Nadu. Tamil Nadu.
Tamil Nadu matter is ninth.
Yes.
Fourth.
I have,
Twenty-six
I
is
have-
also, my lords, with respect.
3 and 26. Both are on, done
Just-
on fourth.
there's one small issue I want to flag in this, Manoj. We placed it on record as well. That because of these Anganwadi workers and the teachers are the ones who are recruited as the BLOs, there's a lot of severe pressure on them to meet certain targets. We've had so far 21 suicides. Now, this is something your lordship will take note of, not today, but on fourth, please consider this. There's something
Remind
that
us
has to
on
be
fourth.
done. It's very severe for,
Even if there are common arguments, then you
Yes.
can separately point out.
yeah, separately I'll point out. Not on the legality, but there's just a human issue, my lord.
You are
It's very
saying
difficult.
Anganwadi should not be assigned to.
Yes. We'll give it on that. Yeah, we'll translate it.
No, no, fourth.
The date has been extended to 11th for SIRs for the compliance of the enumeration form. It was till what, till now? Till 4th, now it's been extended.
11th.
That happened yesterday.
Extended till 11th. Okay.
We'll place that on record. That came yesterday,
Taking up.
on 4th. I'm grateful.
Item 26 also. Item 26.
Fourth.
Read.
3 and 26 both.
Yes.
Please, your lordships, we are being led by Mr. Siddharth Bhatnagar. I'm seeking a passover. He's on his legs in court number 6. Your lordships, in this matter, we are being led by Mr. Siddharth Bhatnagar. He's on his legs in court number 6. I'm seeking a passover, your lordship.
What do you want? You want passover, you want adjournment?
Passover, your lordship.
All right, one passover.
May I please your lordship? My lord, a case of a owner of a copyright versus the infringer. Imagine, my lord, Alan, Solly, Van Heusen, household names.
Authority name for investigate.
Taken away my right on the copyright. Taken away my right.
My lord, complete.
How?
Section 63, which gives me a statutory right, taken away. I can't go for artistic label under 63. If order has vast consequences.
I cannot do any property. I cannot take any enforcement action.
Yeah, that the tag.
Yes, exactly.
That is the duplication of the
Exactly.
violation of copyright.
Exactly. Section 13 directly covered. 63 gives me a statutory right.
Therefore, issue notice.
Lord, stay in the meantime.
What they will do?
No, my lord, because I can't file any action under copyright if this order is correct.
We'll have to set aside it. You serve them dusty at the earliest.
Lordship, make it returnable on a
Next
early
week,
day.
dusty.
Lord, can you make it returnable on an early day?
We are giving date.
Very well. Lord, only one thing, let it be in abeyance. I can't carry out any other infringement action at all.
You
Your
can't
Lordship, I
because
just
there is a
clarify this.
judgment against you today. You can't because there is a judgment against you. Unless that judgment is interfered with, how can you
It's in
be?
the teeth of the statute.
No, that will be.
All right, one line that this will not come in the way of the petitioner
Wait,
immediate
wait,
action.
wait for week 10 days, wait for week 10 days, give a short date.
Sure, very much, gratefully.
Item 6, please.
Lordship, I am for the respondent number 2, Lordship. We have filed the SLP challenging the same order, my lord.
Hmm?
That is, that is just
Maintainable.
The file,
Beg your pardon, my lord?
what,
Who should file?
the person who is affected, he should come forward.
Yes, my lord, I'm affected also.
How are you
The
affected?
wife of the deceased is affected because the High Court has accepted the second FIR.
Yes.
The second FIR bypassed the wife's
Mr. Bond,
FIR.
That is not on the
The
challenge.
wife's FIR is the first FIR.
Question of the FIR. You are asking anticipatory bail for some person.
No, I'm not
According
asking.
to has been filed
No,
sleeping.
I'm not asking.
What
He
you are-
may get, he may not get.
Then
See page
there is
4,
nothing
last
to-
3
nothing
lines.
to-
Anticipatory bail, then there, what is there?
See page 4, last 3 lines. This is what is against me.
Yes, yes.
He's accepted the second FIR. And he's
These poor
accepted the
people are being
preliminary
exploited
inquiry.
by- That's all, different sides.
See below the last 4 lines.
Yes, please.
He's accepting the FIR story, second FIR, which removes the name of the accused person.
4 line at page?
The last 3 lines, at this stage, it cannot be said
Huh.
that no prima facie case is made out against the present appellant in this is the second FIR.
Yes.
How does it matter?
He has bypassed my FIR and gone to a second FIR. Now kindly see the statement of the wife.
This observation is against whom?
This observation is against me because
No.
my FIR has been
Please see
bypassed.
the member parties at page 1. Please see page 1.
Yes, my lord.
Member parties before the High Court.
Yes, my lord.
The appeal, the name of the appellant is there. So when the word appellant is used, this is only with reference to this person.
No, my lord, this isn't, I'll tell your lordship.
Please see.
The
We are
accused
only
there.
citing out from the paper book. Please
Yes.
come to page 1 for a moment.
Yes, my lord.
It is not a case of more than one appeal. There is a single appeal before the High Court.
No, my lord, this appellant is in,
Please see the name of the appellant. There is a person specifically named as the appellant. And
Correct,
when
my
you
lord.
read page 4 last line,
Correct,
the
my lord.
appellant means this gentleman.
But my lord, in my FIR, the appellant is somebody else. The accused,
Mr.
I'll
Court.
tell your lordship what happens.
That
The
is not the
main
action
accused-
challenge before us. That is not the action you are challenging before us. You are asking for anticipatory bail for a person.
Anticipatory bail, my
You
lord.
are challenging, please see your
I'm
prayer.
not challenging this order. He may get, he may not get. What, I'll tell you, lordship, the wife has filed an FIR.
anticipatory bail, we have.
The accused there, the wife has filed an FIR. The accused there is a particular politician.
Yes.
Now the police
Petition pending.
take the
This is the
second
most
FIR.
unfortunate situation where we don't want to comment, but I think some particular vested interests are exploiting the poor marginalized people. That's one. This is the unfortunate thing.
So I'm the wife. I want to register my FIR.
Yes.
That FIR has been bypassed and the court has accepted the second FIR. Kindly see the wife's statement. That will make it clear, my lord. Kindly turn to the wife's statement.
If there is anything against you, Mr. Collins, you approach the High Court, you come to us, we will hear you, we will allow you, the doors are open for you. You are now fighting a proxy war for someone else.
That's correct. With the High Court order, if your lordship says that the High Court order,
Pending.
just say this much.
115 is pending, go and raise all the
Said-
contention there.
This observation of the High Court will not come in the way of my.
This observation is not against you. This observation is against Rajput.
Yes, my lord, but it's.
And as far as, please come to page 115. Mr. Collins, please,
The person who is investigating this case, my lord, is incompetent under 7A. That is what the case is, my lord.
just a minute.
Yes, my lord.
Page
May I say
115.
one thing, my lord? If your lordship's clarify.
Can you please help?
Yes. Yes.
We are trying to assist you in the matter, please.
Yes, my lord. Page.
115,
Yes, my lord.
see the member parties. It is your writ petition which is pending before the High Court.
Yes, my lord.
So whatever you want to
Where I
raise
was-
about you,
yes.
raise those contentions there.
Can you say this, my lord? That this observation in this order will not affect my petition before the High Court.
Obviously it can't.
That's all that I want.
We have heard non-senior counsel for the petitioner as well as non-senior counsel representing the caveated. In our counsel opinion, the observations made in para 4 of the employment order by the High Court do not pertain to the petitioner in bracket Reva Adivasi, as she was not the appellant before the High Court in criminal appeal number 10005 of 2025, which has been decided by the impugned order. Let's see. On the other hand, the petitioner's writ petition number 31491 of 2025 is still pending before the High Court. The petitioner shall thus be at liberty to raise all the contentions before
Yes.
the High Court, which shall be considered in accordance with law. In accordance with law. It goes without saying that the observation made in the impugned order shall have no bearing on the pending claim of
Very
the
grateful.
appellant.
Great.
My lords, I was, my lords, appearing for the victim, brother of the deceased, my lord.
Respondent
I
two.
had, yes, no, my lords, not respondent number 2. Respondent number 2, strangely, my lord, is the person who, my lords, preferred this
Respondent two has,
This is, my lord, respondent number 2 trying to orchestrate a benefit onto himself to the wife of the deceased, my lord. May I just make a submission, sir? This, my lord, is a gross misuse of 136 jurisdiction, my lord. Kindly see, my lord. The wife, my lord, sorry, my humble apology. My lords, the wife. This is, my lords,
these are the issues with the trial court will take care of it.
my lords, wife of the deceased is being made to bat for, my lords, the main accused, who has 2 FIRs against him.
We can't
One
comment
abatement to suicide and one, my lords, derogatory remarks on, my lords, a man belonging to lesser privileged society.
We don't want to comment at, that will have very serious unnecessary
well.
impact on the pending proceeding.
Hello. In
Item
this
7.
case, my lords, the petitioner is a licensed pharmaceutical, my lords, pharmacist, my lords. Now, my lords, he sold.
Without verifying license,
there is
without
something.
doing anything. And 8,000 bottles.
No, my lord, that's what I'm saying. That's factually incorrect, my lords.
Bottle brand, brand number is it?
My lords, may I just clarify, my lords? Allow me. 810 bottles I had sold, my lords, not seized from me. It is seized from somebody else. 810 bottles. I am not concerned with that. The police comes, my lords, 72,000 bottles which I have purchased against.
From your premises.
Yes, my lord, because 72,000.
They have not seized because that you are not you don't have a license to wholesale
I would have misused 72,000, my lord.
retailer.
Yes, my lord. I would have misused the 72,000.
46,000.
Listen, I have 2 answers to this. My lord, the 72,000 bottles have nothing to do with the crime at all. 810 are there.
Thousands of bottles brand mark has been erased.
My lords, these 72,000, my lords,
If your one supply of 8,000 bottles has been
800, my lords. Not 8,000, 800.
all right, 800.
Yes, my lords.
Maybe that next time you will hit 1,000.
No, my lords, I'll not. My lords, what I am saying is, I am respectfully saying that these bottles, my lords, the manufacturer, these are regulated, not banned drug, my lords. It is a regulated drug permitted to be sold on a prescription. My lords, the manufacturer who is situated in Himachal was inquired whether these batches have been supplied by you or not. The manufacturer gave a batch-wise list of 72,000 bottles. I have filed that letter. It's a part of the chart sheet. 72,000 bottles, my lord. Today, my lords, I cannot be given a civil death, my lord. They are costing around 1.27 crore. So these are tax-paid bottles, my lords, with a concentration which is medically permitted.
Problem is, please appreciate, our concern is only that thousands of bottles, not one, thousands of bottles where the manufacturing that number
this
has been erased.
My lords, not in this, my lords.
Yes, sir. According to you, 800 bottles, maybe we read somewhere wrongly in the record.
My lords,
I mean, even if the 810 bottles, look at, these are found with a person who is not having drug
there are
license.
2 different things. Allow me. That's
You
why
are saying
I am
that he will supply. Can you in a medical or in drugs or in pharmaceutical industry. Can you afford to supply like this without verifying?
Yes, my lords, that is an error, my lords. That's what I'm saying. There are two different aspects. 810 bottles, I may have sold them without prescription. But seizing my entire stock, 72,000, which has nothing to do, my lords, is something, my lords, which is complete. And it is seizure, my lords. I'm just seeking release, my lords, and suitable conditions may be imposed
No,
always.
release means what?
My lords have,
That you again you.
no, my lords. My lords have taken a view that
It's a very
it may be
deep
released, my
bracket.
lords, subject to imposition of condition. It is just like bail, my lord, that conditions may be imposed. The police may verify the batch they have sought from the manufacturer. Please see, my lords, the document.
163. What? We don't know, this may not be even original product.
My lord,
Please see page 146. It's a very, very serious allegation.
163,
163.
third line from bottom. 46,800 bottles having
Rather-
erased batch numbers.
Now, even before that, brother,
that is with
just see fifth, the accused confessed that Onrex cup syrup with erased batch numbers and relabeled Onrex cup syrup were kept in
that is
storage.
that's what I'm
Where
submitting,
it
my
has
lord.
been-
That is just a confession.
Correct.
The
We
confession
ignore
has
the
to be
confession.
tested during the trial.
We ignore the confession.
Yes.
When the recovery takes place, 46,800 bottles have no batch numbers.
Batch number.
How are you going to connect
My
it
lords,
with your supply?
with due respect, my lords, just come to my confession, my lord. It is just,
Forget confession, sir.
No,
It's a recovery.
it is just a
It's a-
confession, my lord. Recovery is of 810 bottles.
It's not a confession that somebody will take by force. You are, the number is mentioned. ONTS number is meant. ONTS number 1366
Batch
has
number.
been erased.
That's batch number, my lords. Batch number.
Huh?
My lords may just come to my confession on the basis of which they are saying. my
No,
lord.
no, no. We are
What they say is,
not a confession that you have committed some murder or something without any evidence. These bottles are there in the report, in the store. Out of these bottles, out of 72,000, 46,800 bottles.
No batch number.
Batch number is erased or batch.
there is no recovery except 810 bottles. I
Brother,
filed the charge.
it's a
If
question.
there is no
public-
recovery, what are you saying? If there is no recovery, what return are you asking for?
My lords, 810 is the
Sir,
recovery.
You are asking for return, right?
My lords, of the 72,000.
Correct.
Difference.
So,
Which are having batch number very.
no, they don't have batch number. 46,800 do not have batch number. That is exactly what we are trying to point out to you.
Let's,
Page 163, last three lines. Please read it.
160. May I just read, my lords? I'll just read from 2-3 lines above because that.
You will try to read because that is the confession. We are not on the confession.
Very dangerous.
Bring it on the recovery.
Next facts are very, very alarming at page 164.
On dated, my lords, I'm just reading from the above.
Without a-
On dated 27. Yes, my lord. May I just answer? My lords, read that, my lords. I'll just clarify that. I'll first read that. My lords, I'll start from some 8th or 9th from below. It says, on dated 27/28, when Butchi Sahu informed that goods had been caught in Riva and refused to take delivery, citizen memorandum statement also acknowledged one Rex cough syrup with Butchi Sahu on production by Arvind Jain and Oppo Mobile was seized so and so. Names of accused Arvind Jain and City Jain were added and arrest wait. They are remanded and registered bill voucher seized. Inspection carried out. Accused confessed that Onrex cough syrup with erased batch number, relabeled cough syrup were kept at, now this is the confession which they are saying, at the Guwahati Godar storage and production by the accused of monitor, CPU, printer, and Oppo mobile, GST invoices, bill voucher. Sales summary, Guwahati Godown were found, my lords. 46,800 bottles of cough syrup having erased, they are saying, my lords.
So stop there.
I'll answer that. I'll answer that.
Now answer it.
Allow me. I'll answer that.
No, remember you did not read.
Yes.
Answer 46,800.
There is one more figure after that.
So that figure is a small figure. we know the relevant page to connect
10
it
more
to that
seconds. Stay
figure.
with me, my lords.
And
10
we are on 46,800.
It
You
is
answered that.
72,000, the one which I am arguing, my lords, and I'll justify that. That's why I said, just give me 10 more seconds. 46,800 bottles of cough syrup having erased batch number, and I'll answer this. And 25,200 of Honorex cough syrup, batch number so and so, total 72,000 for which I am arguing today. My lords, for which I am arguing today. Total 72,000.
You are arguing for 72,000.
Yes, ma'am.
You are
Now,
accounting for 25,000.
my lords, I am saying entire 72,000 because if my lords may total this 25,000 plus 46,000 something. Now
Better we
72,000.
don't read the facts on the next page 164. It's a complete deep-rooted racket. A young woman is also being exploited. She has made a statement that she is being kept as a second wife, and how through her the entire cash amount has been deposited in
My
various
lords,
accounts.
assuming, my lords, the prosecution's allegation is correct, just come to one document, my lords, letter dated 5th of August, P7, page 231. My lords, when they seized this stock of 72,000 bottles, I'm not on 800. When they seized it, they asked the manufacturer that, have you supplied these bottles? Give us the batch numbers and this. The manufacturer sent them a letter.
Unfortunately, earlier I didn't want to say anything. I know much better than anybody here about the manufacturers of these pharmaceutical industries in Himachal bordering Punjab. 3 families I got arrested of these industries, and I have been paying a huge price in terms of that.
With due respect, that may be an extreme.
I don't want
My lords,
to.
I have another
Families I got arrested them because they are a deep-rooted racket. All the drugs which are controlled under controlled order are being.
But with due respect,
misused by
today, my lords, the manufacturer is permitted, my lords, he is allowed to sell, he is not made an accused, my lords. Just
Thank
come
you,
to one
thank you very
document,
much, thank you.
231,
Not a case
231, my lords.
issue.
It will amount to his
In light of
death, my lords.
In light of
Amounts
at page 163 and 164, it's not case we can.
My lords, 231 may be seen, my lords. Just two, for my satisfaction. 231 manufacturers was asked, did you supply these 72,000 bottles? The manufacturer, my lords, today manufacturer is not an accused, admittedly. He is having license by the drug controller of India to manufacture these drugs. He is having permission to.
By the way, who is your manufacturer in Himachal?
Yes, my lords.
Which place? One in your Pathankot?
231.
No, what is the name at place?
Himachal, my lords, this.
Place Kalam or?
No, Solan.
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 Thank you.
Lords, he is not an accused, my lords. And he has, my lords, he has amply verified all the
petition, no case to interfere with the impugn made of this.
Lords, I had just one more submission before dictating the order, my lords. I had just one more submission. The Allahabad High Court and Delhi High Court has taken a view in the context of same solution. In the context, this is a different argument. Same solution with 10 mg with the same concentration of codeine.
We'll cross that bridge, sir,
It
when
will
it
not
comes.
fall under NDPS. It will
don't
not
worry.
fall under
Don't worry.
NDPS.
We will see.
We'll consider.
Allahabad and
Don't
Delhi High
worry.
Court
Yes, we need to correct those orders.
fall under NDPS.
You are right. We need to correct those orders. We'll do that.
It is based on a central government order, my lord.
Yes, we will take into consideration central government order and.
Today, please appreciate if later on it is found that this drug is not at all covered by NDPS. It is a perishable drug quantity of 6 months life, my lord. 6 months shelf life. It will become waste, my lords. I'll die a civil death.
Go and approach the authorities. Whatever.
My lords, may I request for a liberty, my lord? This issue I did not agitate in all fairness before the High Court that it is whether it is not covered by NDPS or not. That liberty may be given because tomorrow if it transpires, my lord, that it.
I'm not to say we are of the view the percentage of the drug is not a relevant consideration. Nature of user is a relevant consideration. When it is used for non-therapeutic reasons, below 2.5% will also be a narcotic drug.
Yes, sir.
And and better the authority destroy it instead of
auction kar dega.
My lords, what I would say last before leaving the podium, my lords may impose condition that I'll not sell over the counter without a prescription, my lord. These conditions, my lords, have imposed earlier.
Sorry,
He'll die a civil death, my lord.
Something we don't know how many entire generation can be spoiled with it. These are supplied in schools these are sold near the schools, colleges, God knows.
Grateful. I'm grateful. We hold hard cases at times.
Honorable,
आपको जो लैंग्वेज में कन्वीनियंट है उसमें बात कीजिएगा, है?
okay,
हाँ,
sir,
बांग्ला में बोलना है तो हमारे मेरे ब्रदर को समझ लेंगे, हिंदी में बोलना है तो हम समझ लेंगे।
okay, sir. Thank you, my lordship. To maintain the decorum and to save the valuable time of this court, I have
देखिए,
taken a written argument.
आपको पहले हम बिल्कुल प्लेन उसमें समझा देते हैं,
हाँ, sir.
है? ये जो भी सिलेक्शन आपका हुआ टीचर्स का, ग्रुप CND का जितना भी था ये,
हाँ,
उसमें टीचर्स भी थे, नॉन टीचिंग भी थे।
Yeah.
आपका टीचिंग का है?
मैं उसमें से नहीं हूँ, मैं उसके पहले का, मैं ऑर्डिनरी एज ए कॉमन।
हाँ, तो आपको तो वैसे ही जितने भी असिस्टेंट टीचर थे या नॉन टीचिंग थे, वो सिलेक्शन में कोर्ट्स को लगा बंगलिंग है, पिटीशन फाइल हुई, हाई कोर्ट ने सारा सिलेक्शन प्रोसेस उसको सेटिसाइड कर दिया।
Yeah.
सुप्रीम कोर्ट में आया, सुप्रीम कोर्ट ने उस जजमेंट को ठीक माना और इसी कोर्ट में जो हमारे चीफ जस्टिस साहब थे उस वक्त,
हाँ.
उनके साथ हमारे जज साहब थे, उन्होंने वो डिसमिस कर दिया मैटर।
हाँ.
मामला खत्म हो गया। अब आप कह रहे हैं कि इंडिविजुअल कुछ कैंडिडेट जो उसमें ठीक थे उनको रखा जाए, यही है ना आपकी सारी स्टोरी?
मैं
तो आप चाहते क्या? आप इसका मतलब उस जजमेंट को रिव्यू करवाना चाहते हैं पहले वाले को?
सर,
आप रिट पिटीशन फाइल करके,
मैं एक्चुअली इस जजमेंट को चैलेंज नहीं कर रहा हूँ। मैं इस जजमेंट से जो कॉन्सिक्वेंस है, जो अभी पब्लिक इंटरेस्ट में आ गया।
देखिए, आप ये कहते हो जी उसमें कुछ विडोज हैं, कुछ बच्चे गरीब हैं, कोई स्पेशली एबल्ड हैं, उन सबको नुकसान हो जाता है, गलत सिलेक्शन होती है तो उसमें सब पिस जाते हैं।
लेकिन सर, टेंटेड जो है,
ऐसी कोई जादू की छड़ी नहीं है उठा करके बोल दे कि ये हाँ ये ठीक होगा और ये गलत होगा। तो पूरी सिलेक्शन ही जब गलत है, प्रोसेस ही गलत निकला, तो उसमें क्या कर सकते हैं? दोबारा सिलेक्शन होगी, जो अच्छे बच्चे हैं दोबारा सिलेक्ट हो जाएंगे।
लेकिन सर, whenever the tainted list is here, then
थैंक यू, इसमें कुछ नहीं कर सकते हम। We have heard the petition in person. The instructed petition is nothing but an attempt.
My lords, if I may assist.
Seek review of the judgment dated 3rd April 2025, passed by this court in SLP Civil number 9586 of 2024. No case to entertain the petition made of dismiss.
My lords, if I may assist, I'm in some other connected matters I was. My lords have sent a number of the SLPs with the similar concerns to the High Court. So if leave may be granted for him to approach the High Court, then
He is not the candidate, unfortunately. Had it been so, then we would have sent him back.
his wife, I'm told, is. So his wife was a
Some
candidate.
candidates
And
are
his,
there, they can always approach the.
so my lords, if they may be granted leave to approach the High Court, then the High Court may consider locus, etc.
However, in terms of the earlier directions, leave is granted to the petitioner, to the affected candidates to approach the High Court.
thank you, my lord.
My lords, this concerns the SIR in West Bengal. So the matters are coming up on the 9th in any case. 9th?
We'll take up on that day.
My lords, just one thing that I may place with my lords to consider on that day, which is that I am for mainly Hindus, but also Christians, Jains, Buddhists, etc., from Bangladesh. Now, we came to this country, my lords, because we were told we were going to be given protection under the CAA. But even though we came prior to 2014, our applications have not yet been processed. My lords.
On that day, you please remind us
Yes, my lord.
You have a separate argument,
I have a slightly distinct argument.
slightly distinct argument that will allow you to raise this argument.
I'm so grateful.
But our problem will be that we can't really draw distinction only because somebody is Jain, somebody is Buddha or Hindu or anything. We have to go by. Deemed citizenship is there for those who are persecuted in the
Persecuted minorities in Bangladesh,
I think
Pakistan.
neighboring country on account of religious background.
Yes.
That right is there.
Yes.
But that right, as my brother says, and rightly so, that has to be on case-to-case basis. That actually I was there, I belong to so-and-so religion, and I have been subjected to the religious persecution, and therefore I am entitled to. Somebody will have to, on case-to-case basis only it will have.
My lords, I'll give you a short note. I am just seeking what my lords have already decided in the Basudeo judgment to say two things. Number one, that there should be expeditious decision on my application, and that my lords have already decided, that is decided law. And number two, that I should be provisionally on the SIR. But my lords, of course, if the SIR goes, then I'm home free, so that's fine.
So the other matters are on 9th.
I'll do that on the 9th, my lords.
All right.
My lords, notice may be issued so that they can reply.
Copy to the state.
We'll please. So grateful.
Yes, Lord, I am MMRDC, Lord, Mumbai Metro Road.
Yes, yes,
Lord,
yes.
I am MMRDC, Lord, 34 is pending. I'm ordered to pay, my lord, 100%. There are only two issues in the 34 petition. I, my lord,
Not pay, only deposit.
deposit, my lord. My lord, and they can withdraw also. No, they can withdraw also.
Corporation, they are not going to run away from.
Has said now in Supreme Court recent judgment, three of them, governments don't stand on a different footing. The integrity of the Arbitration Act, your lordship will maintain in 3 Supreme Court judgments. Give me 2 minutes, Miss. That is
I also have 3 Supreme Court judgments.
International 100% deposit. Because Malas, today in arbitration, the whole idea is that governments, what happens Malas, back to back. His money doesn't come to me. I have loans. There are cases which they are cited these judgments where I go into IBC because money due to me.
No, L&T can't go to IBC. What is this?
I'm talking about the principle.
In private,
L&T won't go to IBC.
Somebody will disappear, someone will dissolve, declared insolvent, this and that.
And every government then will Malas get an unconditional stay.
That much at least because the states.
Well, also see 36. Section 36, the Act, is not that kind of a section.
That is interpreted by your lordship.
Deviation. Which supplying?
Second provision.
Yeah.
So.
Yeah, if we go there.
Additional stay definitely. Yeah. Provided follows satisfied prima facie. If these two happen, then it should stay involved unconditionally pending for these two reasons.
Just see that. I'm sorry.
Only one thing.
36(3) ka section. Revisor.
One.
अरे सर मैंने आर्ग्यू किया वो I won that matter.
That's why I'm saying that he will rely on it. I'm telling you.
So what is to be done? Take up the best hitting para. Where is Madhvi? Take up the best hitting para with spam to this. एक निकाल
Spam निकाल.
एक निकालना एक the best हो.
Spam is the best.
नहीं जो भी नहीं जो hitting वाला हो यार not छोटा para.
That's 28.
Of all the three is
CL.NO तो मतलब
This is
favorite.
it's 3 copies of this. यार
पहले मैंने call out किया.
तो ये भी निकाल दे.
okay. एक दो number भी इसका.
नहीं दो. Spam and
You don't read. No, you don't.
You just. Toyo is actually an order. Toyo is just a single page.
You decide. I'm going to. I've seen all three. Decide one which hits.
This is clear.
Doesn't matter that also. I'll only read one para. Which is better?
I think Toyo. Then look at it.
तुम कॉपी रखिए कौन सा अंडरलाइन कर देंगे लाइन से लाइन को
Well, one
Just read the
factor which may
section for a
appeal to your lordship, only a minute. Lord, the contract is over, work is complete, we have already paid 3,000 crore to them. And the main 34, I have examined, my lord, cannot,
of GST only.
it cannot take more than 2 to 3 hours, including both sides.
Now let's
The issue is limited that according to us, it is 10% GST which is included in the contract. If somebody has paid 15, according to them, 6.7. Second point, my lord, which is a smaller point, that this is an underground, my lord, project. So when you are doing underground project and the traffic is going on upstairs on the surface, but you have to put struts so that the land doesn't fall. So they say that my direction to them to put the strut amounting to change in the contract.
Additional work.
Additional work. But it has to be, it doesn't have to be mentioned.
There you have the other member of the tribunal gives a different.
Yes, but there is a dissenting view also.
now Maharaj,
Only one of the two.
we've done.
So, my lord, there are two judgments, my lord, I can assist your lordships with, that 36 is not absolute. It doesn't put, my lord, an injunction on the court granting an injunction. It
No.
depends upon facts of each case, my lord. And having already paid 3,000 crore for the work done,
From them by way of an
Give me
appeal.
just 2 minutes. Your
sir,
Lordship,
I can file an undertaking, but certainly.
2 minutes. Just turn to 36.3 for a minute. Just turn to the section.
Page 32.
No, section 36
Section 32.
of the Arbitration Act, clause 3, proviso. So special provision made for your lordship was under this act. Kindly give this act. So,
See, Dr. it's not the principal amount of the award which is in dispute or something. Yeah, additional claim because you are saying that you have been asked to perform additional work.
well, I'll take only,
Plus, there is an issue with regard to liability of the tax.
so I'll make only 3 points. Just see on the liability of tax also. Just give me a minute. Just first see 36.3. I'm not going to, well, it's a long section. 36.3,
Second one.
your lordships added a proviso in 2021. Would my lord, Justice BAGCHI has got second proviso. Justice Suryakant has got
Section
36
Three.
of the Arbitration
36,
Act, subclause 3, second proviso. This is added by amendment in 21.
And what is the finding?
Yes.
Provided further that
Where
where,
the court is
sorry.
satisfied.
Yes, my lord doesn't have it, yes. Provided further that where the court is satisfied that a prima facie case is made out that A, the arbitration agreement or contract which is the basis of the award or the making of the award was induced or effected by fraud or corruption, it shall stay the award unconditionally pending disposal of the challenge. Your lordship's unconditional stay cannot go beyond the statutory section is point 1. It's a very strong section, which is the basis of the award or the making of the award is induced or effected by fraud or corruption. Now see your lordship saying, just give this quickly, Bam, para 28. Kindly hand it over. Give the other side also.
This proviso is anyway.
First proviso is the one which governs, it's a money.
It's for unconditional stay, Malaj.
One rule 5.
He's seeking unconditional stay.
Dr. Singhvi, we are really concerned with the first proviso. It's an order 41, rule 5.
Yes.
Ways.
Yes.
As to whether a money decree requires to be secured by deposit of money
Yes.
or collateral securities.
I will beg to differ.
There, if it
I
is a
beg to differ. Very
government-
important legal issue. I beg to differ. Second proviso is a further carve out of the first proviso for unconditional stay. First proviso is for normal stays.
So the second proviso.
Your lordship gets 90% deposit, 80% deposit.
The second proviso is only restricting the powers of the court by by using the word shall means
Yes.
that where the court is satisfied about prima facie about these two factors, then the court must stay.
May I?
Then you don't have to say,
again-
"Oh, there is a fraud, but still I will not stay."
May I
There
just-
was a mandatory,
no.
there was
May I
an
just-
automatic stay.
Just say, no,
That is now being
no,
dealt with
Mr.
in the-
Mehta, please. Malas unconditionally appears only in the second proviso. It doesn't appear in the first proviso. Your lordship's power to grant unconditionally, that's the point. It's a statutory bar.
It is not unconditional, will take an undertaking of the managing director.
Undertaking is not conditional. Malas. Even his own arbitrator said deposit 134, the one arbitrator who held in his favor. How can there be a 0%? Malas? Kindly see.
Except that barring some sadistic pleasure, but you will gain by deposit there in court. You are not getting the amount.
134 is awarded by the arbitrator who holds in his favor. How can 250 be leaning to unconditional stay? One more thing. Unconditional is used only in second proviso. Just see para 28 or what I've handed over. Just see it for a minute, Malas. Kindly just turn to para 28. Kindly hand over to my lords. Just 2 minutes, please. Section 36 also does not, please see this. Kindly give a copy to them. We've given. 28 at page 127. This is Supreme Court judgment on this very amendment on this very act.
Yes, yes.
Section 36 of the act also does not provide for any special treatment to the government. That's his whole argument.
Yes, yes.
While dealing with the grant of stay in an application under 34. Keeping the aforesaid in consideration and also the provisions of section 18 for equal treatment of parties, it would in our view make it clear that there is no exceptional treatment to be given to the government while considering the application for stay under 36 file.
The government may not get, but the metro must get in this country.
Would your lordship not consider at least a 60-70% deposit or 50% deposit? That's what lordship does in every case. How can he get away with a clean undertaking, Wallace? And there is no argument that he has paid me 3,400 crores when the amount payable is much more. And now just turn to one more para, since my lord, para 19 of the impugned order. Just turn to para 19 of the impugned order.
Para 19, yes.
My learned friend raised 3 points. I am the government, I am safe, matter will take 2 hours to be over, and GST. Let us see GST, 1 minute, please. Para 19. Please come to page 11 of 21. The page is given on the bottom. Page 11 of 21. It's part of para 19. Does my lord have it? Para 19 of the impugned order.
That's right, that's right.
Third line, fourth line on the next page. It
On
goes
page
over.
11.
Yes.
Yes.
The page, my lord, BAGCHI has got it. The para 19 of the impugned order, High Court order. There is a difference in the section between unconditional and non-unconditional. That's the point I was trying to make. The section bars a unconditional stay without satisfying that. Now see this, Wallace. Now, Wallace, there's one very serious problem. I don't know if it's been corrected. My learned friend has filed an impugned order which does not have many paras. So I'll hand it over. Many paras. Para 19 doesn't have at least the one here.
No, it is there. Para 19 starts page 10.
Yes.
Only 2 lines are.
Very well, your lordship has been favored with the correct
There was
call.
missing, it was added before it came before.
He didn't get the addition. Doesn't matter. That's all right. Next page, Wallace. The bidding took place before the introduction of the GST regime. Does my lord mark that? Justice Suryakant is gone?
Yes, yes, yes. We have already read it.
The parties indeed have consensus that the impact of rationalization of duty, consensus, the framework of the GST and its implication would lead to an impact on the contract price and the consequential adjustments. The parties conducted themselves in line with the GST regime for the residual period. Some of the benefits that were earlier available were subsumed in the wider indirect tax. In terms of economic costs, the dispute really is what is the matter in which these rationalized benefits have to be split. it is seen that the parties indeed engage in minute detail with the specific heads of differences of GST impact. Deshmukh and company, a chartered accountant firm, engaged in engineer in charge. That's Deshmukh is first, engineer in charge second, who also deposed as the corporation witness, came up with an assessment of 22 August. That just see the finding next, just one in August. The tax component was 10.03. The contractor was of the view that the tax should be 6.65. The difference of opinion among the parties centered around the change in taxation under 7 heads. They are given, 7 heads are given. Now come to 22 and 23. After this, why should a lordship be a court of fact in an interlocutory deposit issue? The DAB heard the party, that's the dispute resolution board, on the differences between, and concluded in its report of 2023 with detailed reasons that the component is 6.78. This was not acceptable to the corporation. Indeed, the learned tribunal had the power to open and re-examine the DAB's report. Then let us come to the finding in 23. He says with these 3 findings, engineer in charge, DAB, and then the power of the arbitrators, then he concludes in 23, therefore the scope was wide and expansive, and DAB's report too formed an integral part of the evidence. Yet it cannot be forgotten that the parties may have finely and sharply debatable differences on nuances. Fiscal statute could lead. One cannot lose sight of the fact that these fine multiple competing interpreters meant for consideration in the final hearing. The final hearing is 27. Which para?
37.
What last word? The other side. I got better.
Plus interest.
It is plausible આવે છે. Finding કે
Well, there is another aspect, fellas. It is not just for the pleasure of hurting them that I am doing this. I will withdraw with a bank guarantee. I will use the money. My learned friend will have a bank guarantee for me.
One is that second proviso argument is completely misplaced. That argument is not attractive because there is no finding of fraud. That is only mandatory condition for the court, that you can't have both the things. On one hand, you say there is a prima facie fraud, and then you say I will not grant stay. Then you must stay the award. That is what the import of the second proviso. In this case, it is the first proviso that applies. First proviso is Order 41, Rule 5.
Let us say first, for a very less typical lordship, decide final hearing.
Rule 5, just in Nariman judgment, which you are referring to, Rohinton judgment, is paragraph 29.
20 and 20. The answer to 20 and 20, and then 29.
29. 28 you have read.
I have read 28.
Is applicable.
Well, just 2 lines in 20 and then 29.
Yes.
I won't read. 2 lines in 20. 20 bracket C. I mean placitum C. Mere reference to CPC in 36 cannot be construed in such a manner that it takes away the power conferred in the main statute itself. It is to be taken as a general guideline which will not make the provision of the Arbitration Act inapplicable. The provisions of CPC are to be followed as a guidance, whereas the provisions of Arbitration Act are essentially to be first applied. Now read 29. I don't want to escape 29. Although we have the firm view that the archaic 8A of 27 has no application or reference, we may only add that even if it is assumed that provisions of 27 and 8A are to be applied, the same would only exempt the government from furnishing security. Whereas under 41(5), court has the power to direct for full or part deposit to furnish security dictated amount. So I am saying, well, either of two things not to do. So therefore, let me change my tag. 1, he deposits, I'll take on bank guarantee. He can't be worse off. Or he deposits at least 50%, Malas. How can he get a clean stay? Let him deposit 50%. He's Malas.
So, her land solicitor, say leave granted. The challenge herein is to an interim order dated 10th October 2025. 10th October 2025, passed by the High Court of Justice at Bombay, in exercise of which ordinary original civil jurisdiction, whereby in a petition under section 34 of the arbitrations once act, comma, the appellant dash Mumbai Metro Rail Corporation Limited has been directed to deposit the entire disputed amount, disputed stroke decretal amount decretal amount along with the interest with the registry of the court within 8 weeks. Then say we have heard learned Solicitor General of India in support of the prayer made in this appeal, and Dr. Abhishek Manu Singhvi, learned senior counsel on behalf of the respondent as CL.NO. So, with regard to the nature of controversy, comma, coupled with the and the fact that the contract amount that the substantial part of the contractual amount has already been paid to the respondent contractor, to the respondent, and also keeping in view the spirit and import of Section 33 of the Act, especially the keeping the first proviso in view, we are satisfied that the ends of the justice would adequately met with by directing the appellant to furnish adequate security, other than the actual deposit or a bank guarantee,
Can it be undertaking of the director?
Undertaking unnecessarily that will be private. Any security you can furnish.
No, but for a government entity on behalf of MMRDC.
In Bombay, you must be having a lot of properties. Once one award or one.
The only property is the metro railway. We don't have any.
No. Metro has bound to have some land properties.
It will be difficult for us. Undertaking would be, we would be directly hit by contempt, it would be better for them.
Security dinner. Because
What is security?
it is either deposit, full or part, or furnishing security. So some security or security.
The difficulty is if you,
Adequate
what is
security.
persuaded your lordship is the judgment. There are judgments, which takes the view that your lordship's power to grant even unconditional stay is not taken away by the proviso.
We are not on that. We are not on that. If we are following Order 41 Rule 5, then if it is conditional, it should either be security or cash or deposit of the amount. It can't be an
Some amendment for Order 41 Rule 5 in Bombay. I'm not getting it, my lords. It is, yes. There is no provision under Order 41 Rule 5 of CPC imposing a mandate to deposit cash security as the only mode of security.
That's absolutely correct. That is why we are saying alternatively furnish security.
Further, with your lordship's permission. Security for the purpose of the said provision can be in the shape of property, bond, or in the form of an appropriate undertaking from the appellant to abide by the decree seeking stay of the execution. My lord, this is the judgment of lifestyle equities, my lord, which is 2025. My lord, this is the judgment. My lord, kindly have a look.
He's gone against us.
Step up. Last week.
He's interpreting 41.5.
This is. So this is under 36, 34 of the regime.
Your entire discussion on lifestyle is on 36. You only just point to the 36, which I think doesn't make a lot of population, not the other way around.
This is, my lord, again under 34 and 36 while examining, my lord, Order 41.
Having heard learned senior counsel for learned Solicitor of India on behalf of the appellant and Dr. Singhvi, learned counsel for the respondent, the excavator, we are of the view that there is no legal necessity to. There was no legal necessity for the High Court to issue a direction regarding deposit of the entire decretal amount during pendency of with the registry of the court as a condition precedent for deciding the proceedings under section 34 of the Act. Instead, consequently, we allow the appeal in part and dispose of, we allow this appeal, consequently, we modify the improved judgment of the High Court and dispose of this appeal with the following directions. 1I, the appellant shall not be required to deposit the decretal amount or furnish any bank guarantee as a condition precedent for deciding the proceedings under